Good morning and good afternoon, everyone, depending on where in the country you're joining us from today. Welcome to our annual federal sector update on the 2025 year in review, and it has been another big one for employers in the federal sector. This is the first of 5 seminars that we're going to host over the coming month or so in the Labor and Employment Group at Fasken. So if you're looking for more information on the other seminars, please see our website. We'd love to have you. By way of introduction, my name is Jackie VanDerMeulen. I'm a partner in the Labor and Employment Group in the Toronto office, and I spend about 95% of my time representing employers in the federal sector, including many of you who were kind enough to join us today. So it's nice to see so many familiar names on the attendee list. Before I introduce my co-presenters, I just want to start with some of the administrative matters. So I'd like to draw your attention in particular to the survey point. We love your feedback. It's really important and it helps us shape our programming for next year. So please do fill that out if you have a chance. You'll also see information about CPD credits. There are QR codes and links which will be available at the end of the presentation. Again, if you need more information on that, we're always available to help, but it should be at the end. You'll also get copies of materials after the fact. Joining me today, we are very, very grateful to be joined by Dan Satayeni, who is the president and CEO of FETCO, as most of you know, a really important organization representing federal sector employers. Dan brings more than 15 years of experience in public policy, stakeholder engagement, government relations, and collaboration building more generally to the role. Before joining FETCO earlier this year, Daniel served as the Vice President of Policy at the Ontario Chamber of Commerce, where he led a department that was responsible for shaping the Chamber's policy and advocacy agenda. So we're thrilled that Dan's able to join us and shed some light on some of the discussions that he's been having with folks in government and obviously many of you as well. Next, I'm joined by my colleague, Chris Pigott, who is a partner in the Toronto office. Chris represents many of Canada's leading employers in their most sort of consequential cases and has been very involved in some of the country's biggest labor disputes over the past year, including many of which have resulted in charter litigation on the Section 107 issue, which I think you're all aware of at this point, and which we'll be fortunate to hear a little bit more about today. And last but certainly not least, I'm joined by Emilie Paquin-Holmested, who is both a partner in our Montreal office and the co-leader of our Labor and Employment Group nationally. Emilie is also very involved in the federal sector, including on the advisory side, the litigation side, collective bargaining. She also is part of our pay equity group, so we're thrilled that she's able to join us today too. And with that, we'll move on to our presentation. And I'm going to start with some of the updates that we've seen coming out of the recent federal budget. And I'll start, maybe even before I get there, I should just say, we have a lot to cover today, as we always do when we try to cover all the updates that have happened in this sector across labor, employment, human rights, accessibility, pay equity, et cetera, in a year. So we are necessarily going to have to be high level. We're going to try and get through as much of it as we can. If you have questions, please feel free to put them in the chat and we'll try and incorporate them throughout. But again, given the amount that we have to cover, we may not get to it. Please feel free to follow up with us afterwards. With that, so Dan, I'd love to start with you because I know that, again, you've been speaking with a lot of the policy folks and you have a pretty good sense of from a government perspective, what's going on in the federal sector, as is reflected most recently in the budget update. So I'll turn it over to you to give us some of the context.
Jackie, thank you so much for that. And thanks for the invitation to join you all. Maybe just I'll start with a few high-level comments and just by way of background, FETCO represents the large federally regulated employers at the heart of Canada's critical infrastructure, and to place our mandate within the current government. Prime Minister Carney has bet a big part of his political agenda on a big economic reboot. And that's what he's tabled in the most recent federal budget, major infrastructure projects, one Canadian economy vision, push to make Canada more resilient. And our argument here has been, including through our federal budget submissions, op-eds, and directly with government as well, is that there is a missing link here, and that is labor stability. And without a credible, predictable labor relations framework, those nation-building projects and other ambitious initiatives that the government is looking to get off the ground, including catalyzing some $500 billion worth of investment between public and private partners, will grind to a halt before they begin. Taking a look at this budget, which I know Jackie will explore more point for point, but things like non-compete, wage theft, and misclassification, all these fall generally under the same umbrella as the previous decade government's approach to labor reforms. They are piecemeal, and oftentimes, as was the case with the previous government, are politically driven reforms to the labor code rather than part of a more coherent framework that protects workers while giving businesses the predictability and fairness that they need to thrive. And paid medical leave, I think we're going to be getting into this. This is a good example of well-intentioned policy, maybe the principle being right, but the way it was designed and written and legislated, has all kinds of adverse consequences, effectively doubling existing plans and benefits. And so, that's another area in which we are urging the government to let existing CBAs be recognized when they have employer sick leave programs and have that count towards that minimum 10-day threshold. But again, just stepping back here, ultimately, if Ottawa wants reliable infrastructure and if they want steady growth, they're also going to need a modern, balanced labor relations system to match that economic ambition. And so that is really the question we're focused on at FETCO. And it's fairly simple, which is how do we align the labor relations system with the modern economy and the government's ambition to build and rebuild. And right now, effectively, what we have is a labor relations system that really has not been updated in a more comprehensive way for over 3 decades. And much of the principles in the framework are rooted actually in a post-war era that doesn't contemplate integrated and globally connected supply chains. And Jackie, just to finish off by going back to your original question, I think the refreshing, and maybe if I could end on a little bit of an upbeat note here, the refreshing point would be there does appear to be recognition from this Carney government that, the pendulum over the last decade was very much so focused on a certain, protections for workers, appeasing different asks that the labor movement had, sometimes even running roughshod over employer consultations. Now there's a recognition that we need to make sure we've struck a balance in this. That recognition is running up against the political realities, however, of navigating a politically fraught topic as is labor reform. But at least there's a sense from some of the adults in the room that are responsible for government that at the end of the day, they're going to be left picking up the pieces and trying to keep the economy moving. And they're not going to be able to do that without a more modern and thoughtful framework as it relates to some of these issues that we're going to get into today.
Okay, thank you. That's really helpful context. And if I'm hearing you correctly, I'm hearing sort of, maybe we did swing a little bit too far on labor reforms under the last government, or there may be sort of an implicit acknowledgement to that effect, but difficult to swing the pendulum back. So instead, what we're seeing is kind of little, what we said, modest changes in the grand scheme of things to the federal workplace legislation coming out of this budget. Okay. And So as Dan mentioned, I'm going to get into just a high level what we're seeing and what at least has been proposed in the budget. So some of them bigger than others. We're seeing a change proposed to the Canadian Human Rights Act to eliminate one of to consolidate the role of Chief Commissioner and Deputy Chief Commissioner. We're getting the sense that that's just a budgetary issue more than anything. We know that's an important issue for the Carney government too. They're very concerned about maintaining costs, reducing costs. So not sure if there's anything more to that. For those of you who have been dealing with human rights complaints lately, probably a lot of you know it's a very slow, cumbersome process. We don't have any changes that are designed really to fix that. This seems really more like a budgetary issue than anything else. One of the big headline announcements as well is that the government is going to enter into consultations about proposed changes to the Canada Labour Code that would restrict the use of non-competes in the federal sector. It's, again, consultations at this stage, expected to begin in early 2026. But if the Ontario precedent is any example, what we see there is, again, some exclusions for C-suite employees. So that might be something that could be on the table. Also grandfathering in of existing non-competes, so it would be on a go-forward basis. And not importantly, capturing non-solicits, because I think for employers, ultimately for most jobs, that's kind of the key issue: non-solicitation of employees, of customers, of whatever else it might be, rather than the true non-compete. But it's still obviously going to be a big adjustment if and when that comes into effect. So stay tuned. We'll keep you updated on how that progresses. There's a smaller change in the grand scheme of things proposed to the EI Act as well, in the very unfortunate case of where there's a death of a child and access to benefits in those circumstances. There are also proposed increases to penalties on employers who commit wage theft, which is very broadly defined at this stage. Really, any instance in which an employer isn't paying wages that are due to an employee. And again, there'll be consultations on that in the coming months. I think this is probably tied to what I'll show you on the next slide, which is sort of a broader trend of trying to really target employers in the federal sector who are kind of bad actors, rather than the federal sector more broadly. So this isn't introducing like new paid medical leave obligations. It's really focused on those employers who are typically much smaller employers, not the employers who are joining us on this call, who are, for example, the small trucking companies who really aren't sort of following the Canada Labour Code obligations. There's also an interesting pilot project. I have my own skepticism of how well the federal government tends to do on tech-related, wage-related projects. But interesting that they're looking at a pilot project that will sort of give more real-time payroll information to help process EI claims more quickly. So stay tuned for that. As I mentioned, if I can go to the next slide, there we go. There's also a significant portion of new money allocated from the budget to the issue of employee misclassification, which has been an important issue for the federal government for some time now, what they dubbed the Driver Inc. problem. And so they're proposing to amend the Income Tax Act and the Excise Tax Act to allow the CRA to actually share information with ESTC to try and presumably identify instances of misclassification where someone is paying taxes as an independent contractor and then trying to verify or pass that information on to ESTC to determine whether they're doing so appropriately and in line with the code requirements or not. This is, I think this is mostly targeted at those smaller bad actors in the trucking industry. And just to be clear, I'm not saying the trucking industry as a whole. It's really within the trucking industry, there seems to be sort of two tiers of trucking employers, those who are very much following the code and its requirements, and those who are trying to operate under the radar. So I think it's the second group that they're trying to target. But of course, this is going to impact all employers. So it is the time now, before this comes into effect, to look at your practices with respect to independent contractor employee classification, and to ensure that you're comfortable with how you're making those classifications and those assessments. Because again, as soon as the information starts flowing as between CRA and ESDC, and given the $77 million over 4 years to be allocated to this project, I think we can all expect to see more inquiries, more audits in that regard. That's it for the budget. I'm going to turn it over to Chris now to talk to us about some of the exciting, interesting, challenging, turbulent work stoppages that have happened over the past year.
Thanks, Jackie, and it's good to speak with everyone on this panel. And as I think Jackie mentioned, it has been a pretty exciting year, for better and worse, in terms of government intervention in federal sector work stoppages. Over the last 15 months or so, we've seen the federal government really, I think, be required to intervene in quite a large number of national disputes at the federal level to head off strikes that were having or were about to have a really profound impact, adverse impact on the federal transportation infrastructure in particular, but on our national infrastructure more generally. Now, the federal government's had to do this many times before. What was interesting about the last 15 months or so was that the government did not intervene through back to work legislation. Instead, it intervened under a previously little used provision in the Canada Labour Code called Section 107. Now, you've probably heard about Section 107 by now, probably the first provision that the Globe and Mail has done a dedicated piece on in recent memory. But if you haven't heard about Section 107, you've certainly heard about some of the labor disputes it's been used in, and I'll go there in a moment. But just to back up, Section 107 has actually been in the code for over 100 years. It was first introduced in its initial form in 1918. And basically what Section 107 does is provide the Minister of Labor with a very broad discretion to do such things as the minister deems necessary to secure industrial peace and a few other things. It's a very broad and open-ended power that the Minister of Labor has under this provision. And under its current iteration, the minister exercises that power by either referring questions to the Canada Industrial Relations Board, the CIRB, or directing the board to do things. Now, again, this power has been in the code for decades, but until the last 15 months, it had only been used a couple times to intervene in labor disputes. What became important, really beginning in the summer of 2024, was that the government decided that this was an effective way to intervene in a labor dispute without back to work legislation. And I think it's fair to say that the government did so with quite a bit of alacrity over the course of the last 12 to 15 months. Some of the disputes, even if you haven't heard of Section 107 of the code, you've undoubtedly heard of or even been affected by some of these disputes. There was WestJet in 2024, which was the first dispute the government intervened in recent memory under Section 107. But then both railways in the summer of 2024, Canada Post, December of 2024, and then most recently in quite a high profile dispute, Air Canada in the summer of 2025, just a few minutes ago. Now, all of the ministerial interventions under Section 107 were slightly different, but most of them had two key features. First of all, the ministerial order would direct the CIRB to end the strike or lockout, to do what back to work legislation used to do, to send employees back to work and get the operation running again. And second, the Section 107 order would either impose interest arbitration to resolve the dispute or impose some sort of other process to inquire into the dispute. The key example on the latter point is Canada Post, where the Minister of Labor directed the creation of an industrial inquiry commission under Section 108 of the code as part of the 107 order. And that created a process, which Jackie was actually quite involved in, whereby Bill Kaplan, a very prominent mediator and arbitrator, conducted a public inquiry into what was happening at Canada Post, both in its labor relations and otherwise. So that's what Section 107 orders generally have looked like over the course of the past year. There has been already a ton of litigation over the government's use of Section 107 to intervene in labor disputes. Now, as you can imagine, this litigation has largely been driven by the Canadian union movement, and not just the individual unions but have been affected, but the broader Canadian union movement, who are opposing the use of Section 107 with really full, and I would say unprecedented force. So you've seen challenges almost across the board by affected unions to the government's use of Section 107 to end strikes and lockouts. We don't have a lot of decisions yet, but the CIRB did issue two important decisions in the summer of this year in the Canada Post case and also the BC Ports case that provided some early insight into how the courts and other adjudicators are going to deal with ministerial orders ending strikes and lockouts. First of all, and quite importantly, the board said, a union can't challenge a Section 107 order by going directly to the board. Rather, it needs to go and start a traditional judicial review in the federal courts and go through that normal litigation process to review a government action. There's no easy win, easy access to overturning a 107 order through the board. The effect of that, while it's a technical point, the effect of that is that all of these Section 107 orders, even if they've been challenged, remained in force and ended the work stoppage. So practically had a profound impact on the ground. The second important point that came out of these decisions is that Section 107 itself is constitutional. It doesn't violate the Charter in any way. And that was one of the main arguments that the union movement in these cases had been making. Related to this, the CIRB, I think, gave a lot of us some comfort when it found that certainly there is now a constitutional right to strike since the Saskatchewan Federation of Labor case 10 years ago, but that right is not absolute. And there are lots of limits, including in the general scheme of the code itself, to the right to strike. There are lots of parameters, lots of limitations there. So the idea that the Minister of Labor is using Section 107 to end a strike or lockout per se is not unconstitutional, and it's not even foreign to the existing scheme of the code. But at the same time, the CIRB did sound a couple of notes of caution, and it did say that it had some concern about the use of Section 107 to limit strike activity, when in most prior cases over the preceding decades, Parliament had intervened through back-to-work legislation to end strikes and lockouts. So that's where the current state of the law is on that front. But as I mentioned, I think there are many ongoing challenges in the federal court by the affected unions to all of the particular situations in which the government has intervened over the last year or so. There are, I think at this point, 8 separate judicial reviews in federal court covering all of these situations. They're separate pieces of litigation, but the federal court is jointly managing them. And the plan is, at least as we understand it, the federal court's plan is to hold hearings on the merits into these cases probably at some point later in 2026. There have been a number of delays in the cases so far. And as you can imagine, the litigation is being pretty vigorously fought, lots of preliminary motions on both sides, lots of skirmishes, which I think, like to say that I think by my count, the employers are winning so far, which is good, but it's still very early days. There's a lot of interest in these cases, and the federal court has preliminary schedules in place for interveners to apply to get involved. The first of those timelines are coming up in December 2025 and early 2026. And so many of the main employers associations like FETCO are keeping a close watch on this litigation. Lastly, just a closing comment on government intervention under the Carney government. As I've mentioned, and I think emphasized, Section 107 has really become the main new tool that Trudeau government and now Carney have used to end work stoppages in the federal sector. But I think there are a lot of questions, certainly in the media, over whether Section 107 remains a viable option. As I think everyone on this call will know, QP launched an illegal strike. It was illegal by any measure. The CIRB found that in a decision over the summer, but QP launched an illegal strike in response to the government's use of 107 in the flight attendants dispute a couple months ago. And there was a lot of pushback, I think it's fair to say, within the media on how government was using Section 107. I personally don't think a lot of that pushback was justified, but I think it remains an open question whether the government will be as willing to use Section 107 going forward. That's not the only thing that's happening right now, though, on the intervention front. We had an Industrial Inquiry Commission earlier this year coming out of a BC ports labor dispute that recommended the creation of a special mediator power in the Canada Labour Code that would apply generally across the federal sector. The essence of that power would be that the government could appoint a special mediator to get involved in a dispute. And while that mediation was ongoing, the right to strike and lockout would be suspended. We'll see where that proposal goes. Right now, there is also a Senate committee who's inquiring into work stoppages in the transportation sector and what can be done about them. And it'll be interesting to see what, if anything, comes out of that committee's study of this. And I think that there's a lot of other dynamics that are at play here within government that are really out in front of the lawyers. So, Dan, maybe I'll just turn it over to you to make any final comments on this issue.
Chris, I appreciate that. And, from FETCO's perspective, barring a few unignorable instances, we've been less focused on the politics of a specific dispute and more on the integrity of the system as a whole, and focusing on a rules-based framework in which we can't just have parties simply decide which ministerial or government directives they're going to follow and which CIRB rulings they like and will listen to and will respect, and which ones they will deem rip up on national TV. That's problematic. It's a problematic precedent, no matter what side of the issue you fall on. And that's certainly a point that we've been trying to make loud and clear to government. I guess the one point, Chris, that I would add here is the urgency to all of this. There is certainly uncertainty, as you rightfully point out, about what is the future of 107. But one thing we do know for certain is we are heading into a fairly dense collective bargaining calendar in rail, in air, on both ports and telecoms. The government does need tools to manage, a major dispute that can't be solved at the table, that has ripple effects for the economy writ large. And, simply introducing a bill to remove Section 107, as the NDP has done, with supportive fodder from the Conservatives as well, in my view, is intellectually bankrupt. And that's where FETCO again is urging government to take a serious look at this. that they will need tools to manage the next major dispute that can't be resolved at the bargaining table. And, Chris, to your point, it is encouraging to see not only the Senate, but the HUMA committee in the House as well, taking a look at Section 107 more seriously. FETCO is actively engaged in both of these processes, and we hope they will be, a genuine effort to surface facts and evidence and not just a political exercise. We are also, I think, it's worth noting here, it's early days, but we are in the process of working with Chris and Jackie of Fasken to build on that special mediator process, as was outlined in the IIC report, and to develop a dispute resolution process that could effectively replace 107, encourage collective bargaining, but also provide the certainty that Canadians and businesses, and frankly, workers are looking for by establishing a phased mediation and interest arbitration process through which the federal government could intervene in a labor dispute in a fair and measured way. But our message on this to government has been clear. Whatever changes that are made, there needs to be a clear evidence-based architecture for protecting the public interest when strikes in critical infrastructure have broad spillover effects. And just to close on this, there does appear to be an understanding within government that this is a vulnerability and that they are going to need tools, and that they're ready to listen to reasonable proposals. And that's exactly what we are hoping to bring forward and coalesce, a coalition of the willing around a reasonable and thoughtful evidence-based proposal that would respect worker rights, but also bring some clarity to the process going forward.
Thanks very much, Dan. With that, we'll move on to another issue related to work stoppages in the federal sector, which is the ban on replacement workers that was introduced into the code in June of 2025. Now, as I think certainly most labor practitioners on this call will know, the federal government, coming out of the Trudeau era, decided to make a very far-reaching change during its partnership period with the NDP, and to introduce a very broad prohibition on the use of replacement workers during strikes and lockouts. That came into effect in June of this year. As a consequence of the legislative amendments that were made, the code now provides that there is a very far-reaching prohibition on the use of prohibited workers from performing all or part of the duties of an employee who is in a bargaining unit that's on strike or lockout. Now, who are the prohibited workers under the new legislative regime? Well, again, it's quite a broad prohibition. First of all, any employee, whether it's a non-union employee or even a member of management who's hired after notice to bargain has been given, cannot be used as a replacement worker during a strike or lockout. And as many know, in the federal sector, notice to bargain is often given many, many months, if not years, before you actually get to impasse. So the effect of this is that a very large number of employees hired even before an impasse arises, but after notice to bargain, are prohibited full stop from working during a strike or lockout. The prohibition also covers non-management employees who are hired before notice to bargain, but who normally work at a different location of the employer during a strike. In other words, if you have a struck facility or location in your federal operation, you cannot use an employee hired before notice to bargain if that employee normally works at another location. An important note here is that this provision does not apply to managers. So as long as you have a member of management hired before notice to bargain was given, it really doesn't matter where they work. They can be brought in to work during the strike or lockout. There's also a prohibition on contractors who are hired after notice to bargain was issued. So even pre-existing contractors hired after notice to bargain can't work during a work stoppage. And then, perhaps not surprisingly, prohibition on volunteers, students, members of the public, and employees in the bargaining unit who want to cross the picket line. So, in short, a very far-reaching prohibition. There are a few limited exceptions to the ban on replacement workers, but they are quite limited. An important one, though, is that contractors who are hired before notice to bargain can continue working during a work stoppage, but only to perform the work that they were performing before notice to bargain was given. So you cannot use even a long-standing contractor to fill in any gaps or volume that may be created by a strike or lockout. There's also an exception that relates to what I'll call preservation activities. If there's a threat to health and safety, a threat to property damage, or a threat of environmental damage that could impact the employer. But again, there are even limitations in those situations. And the most notable one, to my mind, is that even if these sort of serious threats arise, the employer needs to figure out whether it can use non-prohibited workers in the first place. And also, as I read the legislation, needs to make an offer to striking employees to perform the work first before they can access the exception. So not, in my view, the most practical exception that the federal government's ever come up with. In terms of implementation, we're still pretty early days in the life of the replacement worker ban. There are no CIRB decisions yet that have interpreted this in the context of a live dispute, but I can tell you just from our practice here at Fasken that we know that many employers who are trying to work through contingency plans to deal with strikes and lockouts are grappling with how to interpret the legislation and apply it on the ground. You know, for example, in the federal sector, there are lots of employers who have employees who do not normally work at a single location. They are on the road or they work across a large number of locations. You know, in some cases, that work may cut across different bargaining units because, as we all know, bargaining units in the federal sector are not necessarily tied to a single location. Well, how do you apply the prohibition that applies to employees working at different locations in that context? It's very tricky, especially in an era when tasks can be done via remote work or via the use of other digital technologies. Another question that arises is, how are we going to interpret the contractor exception? Again, the legislation seems to presume that all contractors have a very static workload. And this is just not the case in reality. Many contractors who, especially long-standing contractors, have fluctuating workloads and deal with volume of whatever sort that fluctuates. So it's not as if, you know, you've got a contractor who's just been doing the exact same amount of work over a number of years or even months that can serve as a benchmark for how they need to work in the federal sector or work in the context of a work stoppage. And last but not least, what's interesting is that the language of the provision doesn't appear to only apply to bargaining unit work. It could also apply to duties that involve non-bargaining unit work that bargaining unit employees may perform. And I think a lot of employers have actually realized, as they're trying to build their contingency plans, that they do have many bargaining unit employees who may, as a secondary part of their job, do things that do not technically constitute bargaining unit work. Well, is the employer prohibited from using a replacement worker or a non-bargaining unit employee from doing that non-bargaining unit work? It's not clear yet. And so these are the types of implementation issues that the board is going to need to resolve at some point as these issues begin to be litigated. And on that front, I'll turn it over to Emilie now to give us a bit of information about the Quebec experience.
Thank you very much, Chris. So just a few words on the Quebec experience, and I'll be doing this throughout some of the sections of this presentation, because many of the new modifications to the federal law draw inspiration from the Quebec experience. And this is one of those examples where in Quebec, we've had a ban on replacement workers since the 1970s. And businesses have been living with this ban on replacement workers for many, many years. But obviously, it does not have the same scope as the federal ban on replacement workers. The law in Quebec came into effect at a time where there was extreme violence on the picket lines. And so the entire structure of the ban on replacement workers in Quebec is focused on the notion of establishment to prevent that violence when people are crossing the line. And so most of the ban is really focused on preventing people from entering the establishment. So we do not want people replacing in the establishment. However, there's a lot of latitude on replacement outside of the establishment. And this notion of establishment, considering that it's been a law that has been in effect since the 70s, is being contested in front of the Court of Appeal at this time to see whether it includes modern realities like remote work. And what we're seeing is potentially if the Court of Appeal maintains the traditional notion of a physical establishment where an employer, for example, could lock a door in case of a lockout, if they maintain that, we don't think that the provincial government will be modifying or expanding the ban on replacement workers in Quebec, but we may see it in a subsequent government. There may be a change in government in the upcoming elections, and the provincial government in Quebec may be looking at the federal government and the federal ban to inspire itself on modernizing and expanding it. So for sure, these are circumstances where the federal government is looking to Quebec for inspiration on experiences and on modifying their labor relations laws, but the same way, because they're taking that experience that's maybe not updated and expanding it. We also think that Quebec might be looking at the federal government to see how they will be also reviewing their laws.
Thanks very much, Emilie. And the last thing we'll say about work stoppages in the federal sector before turning to some other topics relates to the maintenance of activities changes that were made in connection with the replacement workers ban. And there was a little known change to the maintenance of activities system that also came into force in June of 2025. And as many will know, there has been a requirement in the code since 1999 that federal employers continue operating during a work stoppage to the extent that's necessary to prevent an immediate and serious danger to the safety or health of the public. That's been in place for 25 years now. And that is, in effect, an essential services protection. What changed in June of this year was that for the first time, employers and unions are going to be required to address the essential services issue in the collective bargaining process. And specifically what they must do, according to the legislative changes, as a requirement is within 15 days of notice to bargain being given, the employer and union must, it is a requirement, they must try to reach an agreement on what services will be continued during the work stoppages in the form of a maintenance of activity agreement. Now, if the parties cannot reach an agreement, which as many will know is a likelihood, then the CIRB is going to need to determine that issue through an application and a litigation process. Historically, maintenance of activities litigation has been very onerous. It's taken tons of time, months, if not years, for the board to reach a decision. So one thing that the government did in the legislative changes was impose an 82-day deadline for the CIRB to make a decision. In my view, and I think in the view of many, this is a completely impractical timeline to litigate a maintenance of activities case. The ones that are proceeding right now have, in some cases, just very difficult to meet timelines being imposed by the board. And I think for good reason, the board is doing what it can and what it must to try to deal with the new legislation. But really, a lot is being crammed into a very short period of time. More concerningly, I think, are probably some unintentional consequences of the change in practice. First of all, many employers and unions have never addressed the maintenance of activities issue in the bargaining context because they haven't had to. But now all federal employers and unions will need to deal with this question of, are we an essential service? What should continue? Do we pose a threat to health and safety risk if we go on strike or lockout? They'll need to deal with this issue in the bargaining context. And as you can imagine, most unions who are about to go on strike or thinking about a strike are absolutely loath to say, yeah, some of our members do not need to go on strike and indeed cannot go on strike. That just doesn't really happen in practice. So this is creating a tense dynamic, almost as a rule in the collective bargaining process. What's even worse is that under the legislation, this is one of the first issues you need to deal with in collective bargaining. So very tough to start things off with such a tough and in some cases toxic issue early in the bargaining round. Lastly, on this point, many of us have a concern that the CIRB, which is already under some stress, it's doing its best, I think, with limited resources in a greatly increased caseload over the last 10 years or so. The cases are just going to become overwhelming from a workload perspective as there's an influx here. So these are all things to watch. Again, we're early days on this front. Dan, maybe I'll turn it over to you to see if you have any closing comments on replacement workers, maintenance of activities, or anything else from the work stoppage perspective.
Thanks. No, thanks, Chris. I appreciate that. Maybe just very quickly on the replacement work issue, because you did such a fantastic job summarizing it. But in practice, what does this mean? Shipping grinds to a halt. Packages go undelivered. Travel is disrupted. Access to internet, telecoms, and banking services is jeopardized. So these are not minor inconveniences. These strain supply chains. They stall critical infrastructure. They erode Canada's global competitiveness, particularly at a time where we're, facing economic headwinds and quite a disruptive relationship with our trading partners to the south. So businesses are unable to maintain operations or maintenance of activities, as Chris is outlining here. During strikes, they lose contracts, they lose market share and consumer trust. And those losses don't simply just reverse when work resumes. And, Emilie was talking about the Quebec example. Well, it's worth noting that evidence from British Columbia and Quebec, which are the only two provinces with a ban on replacement works, they lead to predictably longer and more frequent strikes, lower investment, and greater economic stability. Those two provinces have recorded the highest number of work days lost owing to strikes and lockouts. So perhaps not the best model that the federal government should be following here. And maybe just one last point to close us out very quickly. What's perhaps more alarming is that now, in the way that this has been conceived and implemented, a small bargaining unit, sometimes fewer than 100 people, could shut down an entire company of 30,000 plus employees. So you have a situation in which a small local labor dispute can very quickly spiral into a national supply chain crisis. And you can look at any number of industries and find examples where how this could manifest. Fleet mechanics for trucking and courier companies. Even if mechanics are a small portion of the staff, vehicles can't legally operate if they're not maintained. Baggage handlers at airlines, even if there is a small unit of baggage handlers that end up going on strike under C-58, airlines cannot contract out third-party services to maintain operations. And the list goes on and on. Retail staff that are running the for logistics firms. Strikes by a small number of storefront workers can block a facility and disrupt nationwide logistics operations. And so, there are real world implications to this. And this is, again, an area in which FETCO has been very active on, both with government proposing reasonable reforms, but also in the media, trying to inform the media narrative about this, including in Canada's paper of record, an op-ed in the Globe and Mail on this. So it's an issue that we continue to pursue, but one that we face an uphill battle on as it relates to getting government traction on it. You might see soon populating in your chat. It is a little self-promotional, but if you want to stay on top of the different work FETCO is doing in this space and others, please do give us a follow on LinkedIn to stay on top of all that. Chris, I'll stop there.
Thanks, Dan. Emilie, did you want to provide a closing comment on the Quebec experience in this area?
Yeah, maybe. I just wanted to add a comment to what Dan was just mentioning, because obviously in Quebec as well, we have had the notion of essential services around for a while. Similarly to the new federal rules, parties need to reach a list of what is considered essential services that can be maintained during a strike. Otherwise, the board will have to impose. This is obviously not led to the consequences, I think, that people were hoping. We have seen, like Dan mentioned, very high numbers of strikes and very disruptive strikes in sectors that have not been considered to be an essential service. So they're not considered to, if there's a strike or a lockout, to pose a threat to the health and safety of the public. However, they are considered to be very disruptive. And so the Quebec government has passed a law that's coming into force very, very shortly, where it expands the notion or those rules of essential services to sectors that have an impact on the well-being of the population. And so they're expanding the notion of essential services to services that ensure the well-being of the population. And so again, it'll be interesting to see whether the federal government, after having experienced essential services, the impact on all these other sectors that are maybe not considered essential services, but may have a very significant impact on the population, whether they will go down that route as well, to maintain services and promote that economy that we were talking about at the beginning of our presentation.
Great. Thanks, Emilie. Jackie, over to you, I think.
Thank you both for an update on unjust dismissals. And I don't know what has gone on in this space, but there seems to be an explosion of unjust dismissal complaints in the past couple of years. My sense is it's being driven largely by the new remedies that are available, or the expanded remedies that are available for workers in the event that they are found to have been unjustly dismissed. I think, too, it's probably a lot of counsel are just talking amongst themselves and using this as a sort of tool to put more leverage on employers to try and resolve cases early. Whatever the reason, we are seeing a lot of cases. And because of that, the board is really struggling with how to manage them, such that now you're often waiting a year before you actually see an unjust dismissal complaint come through, and then several years after that before it actually goes to a hearing. And when they do go to hearing, as I'll get into in a little bit more detail, we're also seeing much longer hearings, again, because of the nature of the remedies that employees are seeking under the unjust dismissal complaint provisions. So as you all know, under those provisions, an employee who is a non-managerial employee is entitled to seek a remedy from the board that includes reinstatement to their employment if they are found to have been unjustly dismissed. And that threshold for what is a managerial employee obviously has been set very high by the board. And what we're seeing now, and particularly in the past year or so, 2 years maybe, in respect of the remedies that are actually being awarded, is an expanded, maybe a confirmation of an adjudicator's powers to issue really broad remedies to try and remedy the unjust dismissal. And in particular, we're seeing this sort of tension between what was historically more of a notice model. So where an employee was found to have been unjustly dismissed and was found not to be a suitable case for reinstatement. Maybe there was a breakdown in the relationship, maybe the position had been filled, whatever it might be. There's a sort of various factors that an adjudicator could consider. But where the adjudicator finds that it's not appropriate to reinstate the individual, it historically applied more of a notice model, common law notice model. So however many months per years of service based on their age and other relevant factors. Now we've seen a big shift towards what we call the economic loss model, which is really a much farther or more forward-looking model. So in addition to issuing remedies for losses up to the date of the decision, so back pay to the date of the decision from the alleged unjust dismissal date. Adjudicators are also looking forward and trying to sort of predict how long an employee would have stayed in that role, but for their unjust dismissal. And the rationale being that it's to try and replicate the kind of job protection that employees have in the unionized space, and anticipating that they're going to stay in that role for much of their career, subject to certain contingencies. So if we can show that the employee, for example, would likely have been terminated for just cause in the future because of the sort of existing pattern of what was going on in the workplace before the termination, even if it wasn't just cause at the time, those sorts of things can be mitigating factors that weigh against the remedy. But you can imagine that just trying to get into these issues necessarily requires a lot of evidence, and the stakes are very high because you're looking potentially at damages going forward for a much more than, let's say, 24 months. So months and months, conceivably, of forward-looking service. In Karadakis, which I always struggle to say, the federal court sort of recently confirmed this approach. The availability of the new economic loss model for adjudicators under the code. They did, though, again, try and clarify that you've got to look at all the circumstances. So in that case, they essentially found that the employer had near cause. So it wasn't that they didn't have just cause to terminate, but there were lots of other factors that showed the employee's own behavior contributed in some ways to the circumstance. And that was actually found to be a mitigating factor that lessened the damages that were awarded in that case. But this case went up and down through various different legal proceedings and judicial reviews. And again, just highlights how difficult these issues can be for employers. The court also confirmed, again, that broad discretion. It didn't close the door entirely to the notice model, but we certainly see adjudicators leaning more towards the economic loss model and the very broad discretion that it implies. Another interesting trend that we're seeing in the context of unjust dismissal complaints is the tendency for the board to now proactively flag where there could be a jurisdictional reason why it should decline to hear the complaint, which is a bit of a good news story for employers, I would say. And probably driven in part by the board's overwhelming caseload right now. But under the code actually prohibits the CIRB from hearing an unjust dismissal complaint where another procedure for redress is available under other legislation. So the most common one that we see is where a complaint is actually or can better be brought or can be brought at all, I guess, before the Canadian Human Rights Commission under the Canadian Human Rights Act. And so where that's the case and where the CIRB finds that to be the case, they will decline jurisdiction in favor of the CHRC. And that, in the Theriault decision, the Federal Court of Appeal confirmed that's going to be the case even if the limitation period has expired under the Canadian Human Rights Act, which may leave the complainant with no potential mechanism for redress at all. In the Kaseki, I'm not sure if I'm pronouncing that properly, but I try. In the Kaseki case of the Federal Court of Appeal, the court again confirmed that sort of where the core is an unjust dismissal, where the core, when discriminations allegate, it's a long day, sorry. when the allegations really are truly an unjust dismissal complaint, then the board can defer, nevertheless, to the CHRC, which has the primary jurisdiction to hear the complaint where it involves allegations of discrimination, unless the CHRC specifically refers the matter back to the CIRB. And we do see it doing that. So in that case where the CHRC has done it, even though it does have jurisdiction and by default should be taking on that case, the CIRB will nevertheless hear it. That's the quick down and dirty unjust dismissal update, but I want to turn it over to Emilie to talk about the equal pay proposed amendments to the code.
Great, thanks, Jackie. Just a few words about equal pay amendments to the code. And when I say equal pay, I'm not talking about pay equity. Just to be clear, that will be in our subsequent section. And so, just regarding the equal pay amendments to the code, there's been a new draft regulations that have come out earlier this year. And as a reminder, back in December 2018, the federal government passed Bill C-86, which introduced, namely, new equal pay provisions in the Canada Labour Code. And these provisions prohibit employers from paying different wages to employees who perform substantially the same type of work under similar conditions and in the same industrial establishment. And they can't pay these people differently based on their employment status. And so here we're talking about people working full-time versus part-time, someone who's working on a permanent basis or on a temporary basis. These people cannot be paid different wages. The bill, however, provides for a few exceptions to this rule in terms of if someone is paid a different wage based on seniority, merit, or quantity and quality of work. The bill also provides for certain rules around this prohibition. It provides that employers cannot reduce wages to reach this wage equality. And also, it also provides that an employee who believes that they're not being paid in respect of this rule can request a review of their wage rates to their employer. The employer then has a certain number of days to respond to this request to the employee. If they refuse to adjust the wages, they have to explain to the employee why they believe that the current wages respect the rule. And if they do adjust the wages, they have to do so retroactively to the date that the request was made. However, these equal pay rules have not been proclaimed in force yet. And to support these equal pay provisions, the federal government published new draft regulations earlier in the year, in February of this year. And so what these draft regulations set out. They set out they define certain terms, they clarify certain notions. So they have defined the notion of employment status to include variations in hours of work. So as I was mentioning, full-time, part-time employees. Also includes variations in terms of employment. So as I was mentioning, permanent versus temporary, but also fixed term, seasonal, or on-call employees. The regulations also clarify the meaning of industrial establishment, especially for employees who do not work at one physical establishment. So we can think of people who are working remotely, who work on multiple sites, or require travel within their work. So whether they're working in the road, in the rail, marine, or air transportation sectors. And so in these cases, an industrial establishment will be where the employee most often reports to work, or it could be the home terminal, base, or station of the employee, or it can also be the place where the employee reported to work before the remote work agreement took place. The draft regulations also clarify that only identical types of compensation can be compared. So we can only compare an hourly wage with hourly wage, mileage rate with mileage rate. And finally, the draft regulation also adds a series of exceptions to the equal pay wage requirement. So it allows for practices of red circling employees who are demoted but retain their previous salary. It also allows for increasing wage rates due to difficulty in recruitment. It also provides for exceptions for northern bonuses, so related to geographical location of work. Or payment of employees in training programs. And a few details also on the regulation is that they also provide the requirement for employers to maintain detailed records of the different wage rates and the employer's justifications on those differences. And it also requires that if employees do file a request, to maintain those requests and the answers to those requests on file. The draft regulation also provides that those notices that employers already have to post for federal labor standards must now also include provisions on equal treatment. So these regulations, as I mentioned, were presented earlier in the year in February 2025 and were open to a 30-day consultation period earlier in the year, which closed in March of 2025, at the end of the month of March. And these are publicly available online if ever you're curious to go see them. But some of the concerns that were raised at that time were the impact on unionized and existing collective agreements, concerns on the lack of clarity regarding the identified exceptions, and also the financial impact on businesses that obviously are already going through unprecedented times in terms of business management. The final regulations are projected to be published in the winter of 2026. We believe that this means early 2026 and not December 2026. So we will keep you informed on any developments on that front. Now I'll pass it along to Jackie for pay equity update.
Thank you, Emilie. And maybe before I do, I'll just pause to ask Dan, did you have any additional context, or are you hearing anything? I think Dan's saying
nothing to add from the tour de force that you guys have given. Thank you.
Thank you, Dan. So on the pay equity front, many of you finished your initial pay equity plans last year now in September of 2024, and have already done the annual reporting that was required by June 30th of 2025. If you've been through that process already, you'll know that it includes a whole host of detailed questions about your pay equity plan, but also beyond your pay equity plan, like more specific details about which job classes are impacted, the number of individuals in those job classes, the amount of the increases, and how that impacts your overall payroll, etc. And just quickly to note, for those of you who received extensions, don't worry, you didn't have to file your first statement yet. If you received an extension, which I know a lot of our clients in particular did, because they're large unionized workplaces who are dealing with a whole host of, or non-unionized, but dealing with a whole host of complicated issues in connection with doing the pay equity plan. So if you're in that category, you did not have to file by June 30th, 2025. You'll have to file in the first year after your initial pay equity plan has been finalized, but it's going to be the same date every year. And just for context, go to the next slide. So again, this is just a screenshot example to give you a sense of the sorts of things you're going to be including, but you'll have to fill in information about each individual job class that received increases in compensation, the number of employees, the number of whom are female, etc. This information, I guess, is going to be used for a few different purposes. So certainly the Pay Equity Commission, or the Canadian Human Rights Commission Pay Equity Division, will use that information to inform its audits, which Emilie will get into in a moment. But it's also going to be using this data sort of more in the aggregate, we anticipate, to develop sort of policies and also information and be able to track how pay equity is rolling out in the federal sector more broadly. So it's not necessarily the case that this is all going to be sort of used to get information about your business. It really could just be for the purposes of looking at trends more broadly. I've also included a screenshot here. It's hard to see, but just again, for those of you who haven't already done it, to give you a flavor of what you're going to have to do. So build in some time to do this because you've actually got to do Excel uploads of all of this detailed information, including information about the one-time payments, which we've been assured refers to sort of when you're doing the increase. It's a bit of a confusing terminology, but that essentially refers to when you're doing increases a single time going forward rather than phasing it in over time. But again, give yourself time to fill in this information properly. I think, yes, I'd given you a preview. Emilie, audits. What are we looking?
That's perfect. So like Jackie mentioned, there are upcoming audits that the Commission will be carrying out to ensure compliance with the Pay Equity Act. And earlier this year, the Commission has already announced that it's going to be launching some Blitz audits. Blitz audits are summary audits just to make sure that employers have established and posted their pay equity plan and have implemented the required salary increase. And in doing these Blitz audits, the Commission has announced that it's namely going to target employers that have not received extensions to complete their initial pay equity exercise. So those will be the employers who will be mainly targeted by this, but eventually that might evolve and other information may be used to determine which groups will be targeted. The Commission can also carry out two other types of audits pursuant to the Act to confirm compliance. It can carry out internal audits and can also carry out compliance audits. Internal audits are when the Commission requires an employer to conduct an internal audit and report the results to the Commission. The Commission has indicated that employers can choose who will undertake the audit, including a third-party consultant. And they've also announced that these internal audits will be subject to monitoring mechanisms to ensure the integrity of the audit, including, for example, sharing the content of the audit to the Commission for their review. Also, employers who discover through these internal audits that they have violated the Act or they're not compliant with certain aspects of the Act will have to report it to the Commission and inform and indicate to the Commission what measures will be put in place to correct the identified violations. So these internal audits requests from the Commission are anticipated to start as of next year. The second or third type of audit that the Commission may be carrying out are compliance audits. These are audits that are led by the Commission to ensure that an employer complies with all aspects of the Act. In terms of compliance audits, this is something that Quebec has been living with for a number of years. The experience from Quebec is that these types of audits can be extremely lengthy and very detailed. They can go on for a number of years. And so hopefully we're hoping that the Federal Pay Equity Commission will have learned from the Quebec experience and will put in place a more structured and efficient means of carrying out these compliance audits to avoid backlogs of files and complications for the pay equity plan updates that follow those audits. And so we've had a lot of complications on this front in Quebec. And we know that the federal government has been looking at the Quebec experience in terms of what they're doing with pay equity. So we're hoping that they've looked at what's going on with compliance audits in Quebec and have learned from our mistakes. And speaking of updated plans, so as many of you know, once the initial pay equity plan has been posted, the plan will need to be updated every 5 years. Therefore, for example, most employers who have posted their final initial plan on September 3rd, 2024, and the deadline, must update their pay equity plan by September 3rd, 2029. And before starting the maintenance exercise, employers will have to do a few things. They'll have to post a notice informing employees of the employer's obligation to update. The content of the notice will vary depending on whether employers have to set up a committee are not in updating their pay equity plan. So obviously, if a committee needs to be in place, we need to invite employees, non-unionized employees, to designate committee members and inform unionized employees that their union will be designated representatives for the committee. What's interesting here is that it's different from Quebec in the sense that in Quebec, employers can decide whether they do their pay equity audit, their updated pay equity maintenance with a committee or without a committee. And also the obligations don't vary from one maintenance period to another. At the federal level, there needs to be a recount of employees in the year before the update is due. And a committee needs to be formed if an employer has, during the calendar year previous to the notice being posted, an average of 100 employees or more, or is unionized. Also, a federal employer who has less than 100 employees and is not unionized could decide to voluntarily form a committee. However, an employer who voluntarily decides to form a committee, we believe should not take this decision lightly. Based on the Quebec experience, unilaterally dissolving a committee is not possible for an employer. There needs to be specific unresolvable issues with committees that arise and authorization from the commission. And so if you ever feel the inclination to form a committee, just think about it twice, because once you've set up your committee, it'll be very difficult to undo your committee. And finally, just in terms of the changes made to the pay equity plan, when updating the pay equity plan, employers or the committee will have to set out in a document any changes that are made to the pay equity plan. This is something that we do not have in Quebec, so this is a variation on the theme of pay equity that we see at the federal level. And subsequently, employers or the committee that has completed its updated review has to follow the same posting steps and timelines as those that are applicable for the initial plan. So the same, I won't repeat myself because I'm sure most of you are familiar with these timelines, but 60-day postings with periods allowing employees to comment on the postings will still be required for the updated pay equity plan. And the final version of the plan will have to be posted within that 5-year anniversary from the final initial pay equity plan. What's also interesting at the federal level is that the final posting of the results will have to remain posted until the next update. And in the event that in doing this update, the employer or the committee realize that pay equity has not been maintained during the 5-year period, employers will have to pay adjustments for any pay inequity that arose during that period. Currently, there's not much information on the Federal Pay Equity Commission website on updating pay equity plans, so we'll keep you informed on any developments or any new information that we learn about updating pay equity plans. I'll pass it on now to Jackie for accessibility update, and I apologize for my voice that is slowly disappearing.
Thanks, Emilie. And on the pay equity front, just quickly, as Emilie mentioned, there really is very little guidance from the Commission yet, but there are a lot of questions that aren't answered by the regulations and the legislation. And I don't have a good sense yet of whether the Commission is going to allow employer discretion to sort of interpret the legislation in light of those ambiguities, or whether it's going to come out more prescriptively and try and dictate things like, for example, how retroactive adjustments are made. Once you actually get into the nuance of all these, there are a million different ways that you could structure it, and the Act isn't very specific on those issues. And obviously what the interpretation is going to inform what employers do in the meantime. So this is an area that I think, again, from a resource perspective, is going to take a lot of employer resources in the sort of, I don't know, 3-year time horizon, 3 years from now, as you start preparing for doing your maintenance plan. But if employers are smart and have the available resources, I think they really should be looking at this now. And I know we've talked about this before, but like making sure that they're more proactive in trying to look at their compensation practices annually to ensure that they're not inadvertently creating gaps that then they're going to have to go back retroactively and fix 5 years from now with interest. So it is worth kind of spending the time, if you can, now to try and ensure those things don't arise, because we know workplaces are not static. New jobs are created all the time. Jobs change. Collective agreements are negotiated with new wage structures and all sorts of things. So it's very much a dynamic process for employers, and lots of potential for pay equity pitfalls if you're not being careful about it. Accessibility.
Jackie, do you mind if I just quickly get in on pay equity? Just at the risk of maybe stating the obvious, but just to pick up on a few of the points that you and Emily have mentioned. Employers support the principle of equal pay for equal work, full stop. The challenge, as has been outlined here, is in the rollout and administration. And as a result, and as Jackie noted, many employers, including most FETCO members, have sought extensions and even a second extension. And I do want to be clear on this point. This should not be read as resistance, but as evidence that the process is time-consuming, complex, and at times overly bureaucratic. Just to give you a sense, at FETCO we have 10 different working groups and committees. They all convene on every issue from accessibility to violence and harassment and pay equity. Our pay equity group is the most active. They meet monthly and are asking for even more meetings. And that's not just because they love hanging out together. It's because they are actively trying to navigate what is a very complex environment and share lessons and try to share best practices. But the issue here is an important one. Canada does have a stubborn pay gap between men and women. I think, depending on what industry and area you're looking at, the average sits around 10 cents on the dollar. And, while that gap has been lessening over time, which is good news, it still remains at an unacceptable level. The goal here should absolutely be zero. And what I've seen from stepping into this role some 6 months ago is that employers are genuinely committed to achieving pay equity, and they want to realize this goal with the urgency it deserves. The current system and the current Pay Equity Act is not, I don't think, well suited to that. And, we continuously hear feedback from members that, the mandatory joint committee model is not working smoothly. The legislative requirement to have a single pay equity plan across all jurisdictions in which you're operating in is not suitable to both actual business environments. And now what we're talking about with the maintenance phase is those employers that are lucky enough to have published their plans in time don't have the adequate guidance from a government level to really engage in the maintenance phase in a way that they are confident that they're not going to be missing those gaps as well that you're talking about. So that's another area that now FETCO is trying to push the Pay Equity Commissioner on in a more proactive sense, is where can we look ahead and make sure we're ironing out whatever wrinkles we can and providing that guidance and direction to employers who are trying to achieve pay equity.
That's really helpful, Daniel, because I think that's exactly it. Everyone wants to do this properly, and they're looking for the guidance today to be able to make sure they're set up to do it properly 5 years from now, because these things take time, and compensation models for employers with thousands and thousands of employees don't shift overnight. The more you can do to push them for that guidance, I think we would all appreciate it. So thank you for your work on that front. On to accessibility, and I'll be relatively brief, and we're getting close to the end of our time anyway. But on the accessibility front, so I think as most of you who work in this space know, the Accessibility Standards Canada develops standards, but which are not binding. They're non-binding standards that are developed sort of as best practices in various sort of aspects of our society relating to issues around accessibility under the framework of the Accessible Canada Act. And in May of 2025, it published a revised version of the employment standard, again, non-binding at this stage, but the standard addresses a whole host of best practices relating to accessibility for employees across the employment relationship, including recruitment, hiring, et cetera, all the way to job separation. What we typically see is that these standards then get taken in some way, shape, or form and turned into regulation at a later date. So we are anticipating that there will be a regulation on employment standards for accessibility at some point that is at least inspired by the standard that has now been published, but no news, at least from my perspective, on when we're expecting to see that and what exactly it will look like. Other than we expect a lot of the elements that we've seen in Ontario and other provincial jurisdictions will appear there as well. But again, no precise details yet, so stay tuned. We have on the regulation front, we've seen a draft regulation on information and communication technologies. Again, it's just in draft form at this stage, and it's not proposed to come into effect until 2028 for the private sector, if and when it is finally passed. But what that will do is, much like for those of you who know, again, the provincial accessibility laws, like in Ontario, it will impose certain obligations for employers regarding their websites, also their web applications now, including mobile applications and non-web electronic documents, so digital documents more broadly, to ensure that companies more broadly are incorporating accessibility features into those applications and documents that are being shared with employees and with the public. It would also require accessibility training for employees who are involved in the development, maintenance, procurement of certain digital technologies, amongst other things. So again, because it's still in draft form right now, not too much to report, but we'll keep you updated as things progress. And last but not least, and again, I've just highlighted the draft standards that really are relevant to the employment framework here. If you go on the Accessibility Standards Canada website, you'll see more information about all of the different standards that are being worked on right now. These ones are really just focused on things that would be relevant to people working in the HR, LR space. But there's also a draft standard that's being developed on accessibility and AI, which I think is really interesting. And it's trying to get employers to think more proactively about how AI could inadvertently disadvantage or impact individuals with disabilities, and trying to make sure that you're thinking more proactively about reducing those barriers before rolling out systems, which we know a lot of Canadian employers are working on right now. So if you are in the process of developing internal AI systems, it may be worth just looking at the standard sort of for guidance and inspiration, if nothing else, both as a best practice, but also as a sort of sense of what could be coming down the pipe in terms of regulation at some point in the future. And with that, unless any last words from any of my other panelists? No, everyone's lost their voice. Well, with that, I will say a huge thank you to our audience for joining us today from across the country. We had hundreds of people sign up, and we're really delighted to see such a big turnout. So thank you again. You'll see information here on your screen, again, with that CPD credit QR code that I mentioned for Ontario, Quebec, and BC. And I think we've also added the links to our audience chat. But again, if you don't get a chance to do it now, or just hate QR codes like I do, not a problem. We'll have the information sent to you after the event. You'll have a chance to distribute the materials to others within your organization as well, if that's helpful. As I mentioned at the outset, we're doing a few of these labor and employment seminars over the coming weeks. The next one, I think Emilie is also involved in. It's the Labor Law Year in Review Update. Again, we've included a link in the audience chat if you'd like to register for that. Thank you very much, everyone. And a big thank you to Daniel in particular for joining us today and sharing your perspective. So I know I certainly enjoyed it, and I hope everyone else did. Thank you.